From the law was concerned, when we were retained by Terengganu, we said, look, this is such a straightforward case. What is this? You look at these three agreements. It talks about onshore, offshore. And if there is any doubt, actually there's no doubt in interpreting it. Look at the actual conduct of Petronas. They paid it for 22 years. So what is the big problem? So when we filed this suit in March 2001, we sued both the federal government and Petronas. We were waiting with great anticipation to see the defense. And in June 2001, for the first time, it became clear that Petronas and the federal government was relying on this 3-mile argument about territorial waters. So if I stop there, from 1973-74, when the late Tun Razak and Tunku Razaleigh and Tun Ismail Ali and Tun Saleh and all the other founders of this great petroleum policy of Malaysia, which resulted in the establishment of Petronas, from 1973-74 to June 2001, nobody put forward this highly legalistic technical argument of 3 miles. And credit must actually go to my good friend Cecil Ibrahim, because this is a classic lawyer's afterthought legal argument to help save a political party. And it achieved currency from June 2001. And from June 2001, everybody in this country has been confused about territorial waters. And we are given one big lecture about territorial waters, 3 miles, 12 miles, whatever, when the reality is, for 22 years, Terengganu's oil was found hundreds of miles away. And then, of course, you know, politics, again, because the whole thing is political, when UMNO regained Terengganu, they had a problem. Because, well, now we are stuck because we've got this suit. We can't officially pay Terengganu. But that didn't stop the former Prime Minister, Prime Minister Badawi, about 2 years ago, making a public announcement saying that UMNO is going to reinstate the oil payments to Terengganu. So that was photographed and it was heavily publicized. And then, if there was any doubts, Prime Minister Najib, soon after taking office, made the same public announcement. And I can picture, if you look at the Straits Times, you will see there's a photograph of Prime Minister Najib with a mock check. Now, it is mock because I don't think any payment has been made. But the point I make is, Terengganu still derives oil 150 miles away. So if they had no doubts, if they had doubts about paying the 3-mile thing, surely from June 2001, thanks to Cecil Ibrahim's advice, they now know, well, actually we shouldn't pay. But then can they please explain Prime Minister Najib and Prime Minister Badawi's turnaround and say we will now pay? And all this is because it's political, and there's no other reason for it. Now I come to the Sabah Sarawak. So there are 2 myths about this, and I'm coming to an end. There are 2 political myths about this argument. The first is the territorial waters argument, which I've mentioned. The second myth is the difference between Sabah and Sarawak. They say it is very different. My friends, it's not different. Historically, because Sabah and Sarawak remained under British hands for 8 or 9 years after us, they only joined us in '63, so we are 7 years ahead of them in the imperialist game. In 1954, the British government passed orders in council extending the waters of Sabah and Sarawak. The reason they didn't do it for Malaya was 2, because in 1954, Malaya was still a colony. They could have done it, Downing Street could have done it. They didn't do it for 2 reasons. One is, by 1954, the negotiations for Merdeka was very advanced, and so the British civil service said, why are we caring about Malaya? It's going to leave our hands soon. And number 2, oil had not been found in Malaya yet. Whereas Sarawak, oil was found in Sarawak in 1910. And so they were very concerned about that. But actually, again, it is a red herring. Because Sarawak's right to receive royalty derived not from the orders in council. Sarawak's right to receive oil royalty came from its agreements with Shell. And those agreements have been in place from 1910. So from 1910 to 1954, there were no legislation in Sarawak. Yet Shell paid Sarawak government, but actually the Charles Brooke government, Charles Brooke imperialist family, the British family and British government, whatever, until 1963. So that was the historical basis. But then when we come to 1973-74, in 74, when the PDA came in, because Sabah and Sarawak also signed the PDA, identical 14 agreements and the 14 vesting grants, all what I just said about orders in council and the Shell's right disappeared. It just disappeared. It just erased from the slate. So from 1974 till today, that's nearly 40 years. If two questions are asked, lawyers' questions are asked, and lawyers here can understand where I'm coming from, and then you'll answer it. If the legal question is asked, what is Shell's, what is Petronas's obligation to pay Sarawak, and conversely, what is Sarawak's entitlement, what is Sarawak's right to receive payment after 1974? The answer would be the PDA. The PDA is the only relevant statute governing Sarawak and Petronas. And it used to be 8 to 12% under with Shell, that lapsed. So Sarawak, like everybody else, gets 5%. Sarawak's basis is the PDA. Petronas's obligation to pay Sarawak is the PDA. Nothing to do with 3 miles, 12 miles, or whatever. And again, of course, Sarawak, the waters are far away.